Thì chắc em xin mời lại ba anh chị diễn giả. Please, can you come to the stage to sit down on the chair and now we will open the Q&A section. Mình sẽ có một cái diễn giả tham dự với vai trò trả lời câu hỏi là anh Nguyễn Phương Đồng, nhưng mà anh Nguyễn Quang Đồng ở từ Hà Nội, nhưng mà hiện tại chắc anh đang chưa có vào kịp, cho nên khi mà anh vào thì tụi mình sẽ spotlight anh lên trên Zoom để mà các bạn có thể mọi người có thể đặt câu hỏi ha. Thì bây giờ chắc như mình sẽ mở cái phiên Q&A ra, và nếu mà mọi người ở đây, đặc biệt trong khán phòng, có thể giơ tay đặt câu hỏi cho các diễn giả của chúng ta, hoặc là những người nào đang có câu hỏi ở Zoom thì có thể chat, điền vào phần chat box, thì bên ban tổ chức sẽ nhận câu hỏi và gửi lại cho diễn giả để trả lời cái câu hỏi của mình. Ok, có ai trong cái khán phòng chúng ta có câu hỏi hay là trong Zoom có câu hỏi thì mọi người có thể chia sẻ giúp. Yeah, there's a question in the room. Có một câu hỏi trong phòng.
This question can be for three of you. So firstly, thanks for your presentation. Very impressive. As you know, most of enterprise in Vietnam are MSME, micro and small enterprise, private sectors. So my question is, most of them are business owner, family business. They're not quite aware of the data privacy and protection. And so what they should do in the next few months. Number one, to build a foundation for their businesses. Is there any building awareness in their organization? Any basic tools they can take in terms of technology? And how can they design the roadmap step by step for months or years to come? Thank you.
Just from a legal perspective, this is going to be a challenge for everyone, particularly for, like you said, micro firms and SMEs as well. There is a lack of awareness. I am actually hoping that most of them store their information manually, because that would help to some extent, but I don't think that is the case, because there's, as we can see in Vietnam, there's a great reliance on digital transactions. So thank you to our community for initiating events like this, because these are the events where we want to be able to reach out, even as KPMG, in addition to what we do on a day-to-day basis, we want to be able to help the community and develop this collective need for a privacy culture. It is challenging. I don't think there's a simple answer, but these are small steps that we can take, building awareness in the community, and hopefully one person is going to spread it to another two, and that this will have a multiplier effect. I am sure Ha would have a lot to say about this too.
Yeah, actually, thanks, Amasis, because your answer may be covered for the main point. But actually, from the business side, I would like to add in two things. The first one, for your question, what is the minimum scope we need to consider to implement at this time, especially before 1st of July? For my answer, it should be really depend on your business size, business natures, and also business sectors. I mean the business activity in your organization. But you can set up the standard or criteria to choose what kind of action should be in scope. For example, like for the action interact or have the directly action with our customer. When you collect information, if you that is the online shop or e-commerce, for example, then you consider about the way we handle the data subject right. When we customer come to us and ask some information or ask some privacy right, then we have to think about the procedure to handle it. Or in the other side, like for example, like advertising company, then you sell or purchase the personal data for the purpose of business. You think about the way we comply with the new article under the BDPD regarding to prohibition on the selling or purchasing the personal data. That is the answer for the first question. It really depends, but you can think about this based on the natures and the impact. The second one, I think that the key thing to build up the roadmap, that is the privacy awareness and the cultures. When we have the awareness or even just a really small piece of the idea on personal data or privacy, then that is good starting point. Because even the big organization out there, they same the challenge. When we talk about privacy, we talk about data protection, that's a new topic for them. So for SME startup, maybe the same. And we can start with the really small P, share the news in the market regarding to privacy, update the newsletter for our employee in terms of dong and do, in terms of data protection and so on. That should be the starting point for the roadmap. Yeah. Antti, if you would like to add in any from the technical side.
If I can just skip it, because I think it's more relevant to the Vietnam office, Vietnam market. I think our two members here give a lot of advices, relevant advices. Yeah. So given the position of GeoComply, who is not present in Vietnam yet, I might not be the right person to talk about this.
Yeah. Thanks.
Right, thank you.
Thank you for your question. Cảm ơn câu hỏi của anh. So the next question, we have a lot of questions. So the first question coming from Zoom, I was using English because he wrote in English. My company is an outsourcing company, and sometimes we have to share information about our laborer, such as their name and experience with client. This is a daily task, but registering or notifying Ministry of Public Security can be cumbersome and costly. Is there a way to transfer information about our laborer abroad without having to go through such procedure? Can we use nickname or for our laborer, or can we use the data virtual room typically used in M&A transaction and lock the download function for client? Would it count as data transfer? Very technical. Do you want to? This is a question if you want to.
This is actually, yes, these are the questions that people are asking. So I would just say generally that wherever, if you do not want to trigger the cross-border transfer requirements, then you will have to think about how you can send this data across. And some of the suggestions that you have made are possibilities, but then you have to still assess to see if the whatever plan that you have is secure, and also check that you have met the requirements for under the Decree 13. So it's not a simple yes or no answer. Many organizations are asking the same question. Transferring data overseas has to be done very, very carefully. Anonymizing information can be done to a certain extent, but recall that the personal data is divided into two sections, basic and sensitive data. So even if you anonymize a person, but there are certain data, like mentioned earlier, is available and then is capable of being reversed engineered into personal information through a combination by the person that you're transferring it to, you need to be careful, because you are not supposed to be able to provide data that is capable of being reversed, anonymized or encrypted data that's capable of being reversed and in combination with something else. So these are little things that you have to look at. And my suggestion to you is please consult the people that have given you this advice and look at the systems carefully to make sure that this any information that you're sharing has no features and characteristics where it, if on its own or whether if combined with other data set, is capable of identifying an individual.
Answer? No. Anh Chí không? Okay. Okay, perfect answer. Thank you. Thank you, Amachis. The next question would be, my question is the most distinguishable clarification of the data processor and the third party according to Decree 13. In your opinion, some of the software platform or for enterprises operation are categorized as a processor or the third party? You wanna?
Yeah. Well, that depends, because generally, I think each entity will have to now assess what their role is. So you're right. There could be some pathways that are just third parties, but there could be some that probably have a bit of a hybrid or confused role. So back to what Ha and I were saying, that you need to sit and analyze and see what exactly is your role, how this data is passing through your pathways, and to make sure that whether you neatly fall within third party or whether you neatly fall within processor or whether there is a gray area. And if there is a gray area, then to err on the side of the caution, perhaps you want to then consider your obligations as a processor. So these are the things that would require a little bit more conscious effort and time for you to be able to study that. So always start from the first point. Discover what it is that you do. What is your data flow? How does this come through? So the same thing that both Ha and I have mentioned before. Ha, do you want to add on?
Yeah, actually, I think that that is the in principle we can interpret the definition of the third party and processor. But in terms of business, another point you can consider that in terms of the workflow, data flow, I mean, and the role and responsibility of your organization, because we really have to be careful in terms of define your role, because it impacts directly to your responsibility, your obligation. So in case you still have the confusion on the distinction between the controller, processor, or third party, it should be seek the professional advice to make sure that you choose the right role for your own organization and define right obligation and responsibility to comply with. Yeah, that's all.
Thank you. Anybody in the room have a question? So I can like transfer back and forth between the room.
Thank you. Thank you everyone for the wonderful insights. A question more on the timeline and understanding on risks and key priorities for businesses, for organizations in Vietnam. So 1st of July is the implementation date for the Decree 13. What's your advice looking at, considering that we just have a few weeks now and, you know, doing a gap assessment and then looking into your organization and then being compliant before that date, how is that going to work in practice? So what's your key takeaway for organizations here into talking with experts, doing things internally first, just reading online? How are they going to take those steps that you mentioned, Kaur, as well, into being compliant? And how do you think authorities will look at this on the 2nd of July if they're going to knock at your door? How do you see that's going to happen?
Okay, thank really interesting question, and I hope that I'm Dom in the Zoom as well. So because that's more on the advocacy and also the regulatory engagement to raise the voice. But I will start from my perspective first. Three things to consider in this point. One, on the organization make very clear that we cannot fully comply with the Decree 13 before 1st of July, subject to really comprehensive and the new requirement in terms of privacy. So that is the fact we need to maybe aware of, but actually we have to do at the best effort to maximize the compliance scope. So two things we have to consider at this time. The first one is set up the key prioritize and the gap assessment, also the implementation plan in place. That is the first one, but also when the regulator come on the 2nd of July, knock the door, say something, we at least have the roadmap in place to show our effort. Okay, here is the best effort to comply with your decree. And that is the ongoing activity we do. We take this degree and this topic seriously. So in case you have any further guidance or clarification on our roadmap, we are happy to do so, but please know about the natures of complexity of implementation, about the new requirement, and also the business side, everything. That is the first thing we can push back with the regulator. And the second one, I think that there is some requirement need the further clarification and the guidance from the regulator. So that is the point also we need to take the chance to say with the regulator and seek further advice from them as well to be safe in terms of compliance status after 1st of July. That is my view.
Yeah, that's exactly what I would say as well. And just to add on, you have to start. That's the inevitable truth. And whatever measures that Ha has mentioned are all measures in mitigation, and also to show a concerted effort to work towards to have commenced your compliance journey. It is by no means a one-time activity, it's a continuing effort. So even if you think you have complied, there will be new regulations, guidelines, and you will have to continue. So just start thinking, having the right mindset about complying with protecting data and the regulations as well.
Well, I can draw a parallel to this situation when we roll out our product in the United States for a particular state. Obviously, different states they have different requirements, and we don't always have ourselves prepared when we knock on their door. Can we roll out in your state? And they list out a whole bunch of requirements. We are not ready, but we do have a plan of doing that, right? So they are. Those states, those regulators, they are usually willing to examine our plan and approve certain part of it before, instead of just shut the door down. So I think it's a parallel situation here.
Talking of parallel, I used to investigate privacy breaches in Australia at the Australian Financial Ombudsman Service. And I just mentioned to someone earlier this morning, one of the things that I would look for is the effort. And I would also look at the general culture and mindset of the organization when determining fines.
Yeah, thank you for your answer. So the next question comes from Zoom participant. 3 questions in one. Does the degree apply to employee as Article 17 for data processing without needing consent of data subject, in mentioning about the purpose of processing for the contract between data subject with the organization? Another question is the degree is mentioning about the data subject right to limit the access of data. What the clear definition of limit the access of data and who will it apply to? And the last one is, does the degree provide a clear definition or process to define the legitimacy for the purpose of data collection and processing? 3 questions in one.
So can I look at the questions again? Sure. Thank you for the questions. Yeah. Oh God. So for the first question, employees. So for employees, you have to get prior consent. In the consent, you will have to list down as the purposes for which you need the information. And if there are instances where you do not, where you cannot, do not need their consent, you will, as far as possible, try to itemize it. And also there will be instances during the contract processing period where you do not need to get consent. But there must be an overall purpose that we will be processing this in line with our labor contract, for instance, or in line with the labor contracts and the provisions of the labor law and any other law that applies. So that would protect you to some extent because you have covered yourself. And whenever, that doesn't give you a free pass to just process the application. It has to be in accordance with the law, the overarching principles of the law. The second question is right to access and limit. You may recall I mentioned the data subject is the main driver. So they will decide. And then, as I have mentioned before, if the request you think is going to have any consequences and damage to the transaction in hand, then you want to be able to notify them that you have made this request, these are the consequences, and so that they have one opportunity to review their request and also make a final decision.
The last question, I think it's me.
Does the decree provide a clear definition, process, legitimacy? There is actually no real definition of legitimate purpose, but you would recall that I mentioned that there are 8 guiding principles that you would have to adhere to when processing personal data. So those are the principles that would have to guide your activities, your processing and controlling activities. So for now, I would say pay attention to those guidelines. They are not laws, but they are very good principles that would help guide and provide for a culture where you are actually processing personal data respectfully and also ethically. Do you want to add?
Yeah, actually, I just want to add in one thing, that the consent concept is the one of the basic for any organization or the business to process the data, but not the only one. So we have many exemptions to not obtain the consent from data subject. That may be benefit for the business as well to evaluate case by case and in the really specific context to process the data. So when you decided not based on the consent to process the data, then you have to clearly and carefully to review again on 5 cases that exempt the consent obligation before you processing the personal data. Yeah, that's it from business.
Thank you. Do you want to add anything, Angie? Okay, so I think there's a question in the submitted by the participant in the event. I think very interesting that 3 of you can answer. Is the first thing is the technology to use to do this kind of like protection data protection, and also how to do it cost effectively with practicality in mind. It's very important. It's about cost.
Yeah, so as I mentioned earlier in one of the slides, there are a variety of ways that you can scramble the data before you actually collect it, either scramble or hash it in a certain way. So by the time it reaches our system, we are no longer able to trace back to the user. Even if you pass that information to someone else, even a third party or a fourth party, there's no way they can trace it back because the algorithm just one way. Right, so there are a lot of algorithms like that out there in the market. Right, you can do it yourself, or if you're capable, if your team is strong technically, or if you can employ a specialist to do that for you. About the cost, well, I'm not very familiar, but we have a strong engineering team in GeoComply. Some aspect can be done ourselves. But I cannot say for full certainty that everything is done in-house. It could be, outside the market. We can employ some services outside, but those are the ways that we can look to sort of put ourselves behind a wall. Protect ourselves the first time instead of reaching out to actual data. We scramble it, and we have a layer of protection ourselves.
Thank you. You want to add anything?
Okay, so in terms of the technical measure that company can consider to comply with the requirement in terms of privacy, I think that there are many privacy enhancing technology options for organization can be considered, and based on again the business natures, business activity, and also the budget or the cost. But actually, if we think about the privacy carefully and seriously, then the privacy enhancing technology or the technical measure should be the optimal option to implement, because we cannot, for example, someday we receive a lot of questions from our customer regarding to privacy, maybe 10 or even the 100 questions per day. So how we can handle it without the technology or without the system? So that is the story for that is the situation for the long-term story. But from now on, we can think about it. Yeah.
You want to add anything? No. Okay. Angie, you want to add something?
Just to add to one more point, I think we also have a principle that we only collect the data that we need. So, for example, the transaction that we talked about earlier, we totally don't collect the name of the person. We don't collect the phone number. We don't even collect the address. All we need is those information about the internet traffic or the cellular traffic. Things like signal, which cell tower you're connected to, which access point, Wi-Fi access point you're located to. These are all the necessary and enough information for us to identify whether the transaction is fraudulent or not. So we, like what we said earlier, we only collect what we need and no more.
Great, thank you. And one more question from Zoom, and then I can get back to the room. How to make the data privacy as competitive for an organization? Data privacy as a competitive for organization.
That's really interesting question, at least for me, in terms of two things. The first one is when you visit the website of the company, or you put some kind of personal data in the web form of the company, and again, you still concern your personal data, your privacy right, and we can say, for example, we have the certified like GDPR compliance at the bottom of the website, or even we have the trust mark, for example, that is the international standards in terms of data protection. Then we have a trust for that kind of business or organization. That is the competitive. When you introduce the new product or new service, and you say that, okay, in terms of privacy, this product, this service already were certified by this standard, that standards, international one. So that is also the competitive for our business. And another one, just a small thing, but when we do the due diligence with your partner or you due diligence with new vendor, then they say a really strong privacy culture, strong privacy framework. They have dedicated DPO, data privacy officer, to support you and any your customer in terms of privacy. That's also the competitive thing for your organization in terms of business. Yeah.
Thank you. And anybody want to ask something else for the question? Okay, good. So, okay, anybody in the room want to ask another question? Yeah.
Sorry to take the floor again. Quick question. How aligned is Decree 13 with the GDPR in general, and as well with some of the other agreements that you, Colin, mentioned, like the VFTA and others that have already data privacy inclusions there?
So the international treaties tend to have more broad frameworks about cooperation. With respect to the GDPR, there are some similarities. I could say it's broadly based on GDPR, but there are very many nuances as well that one will have to pay attention to. So if you have a GDPR compliance system, it's a good start, because then all you have to do is do your gap analysis and find out how you can tweak what your existing system and practices are to be able to be compliant. So one example of a distinction would be the definitions of personal data, and so the consent requirement as well. And another major one, because in the GDPR, they have a legitimate purpose rationale or defense, so to speak. Here in Decree 13, like how mentioned, there's just about 4 or 5 exceptions, and they are like in the case of emergency, in the interest of national contract processing. So these are the few limited circumstances. So therefore, you can't use that earlier practice, but you probably want to see how you can reconcile the 2 practices to be able to be compliant with Decree 13. And I think generally with other laws as well, that's exactly the same principle. Yeah.
Okay. Anybody, any question in the room? If not, I will ask a question from the audience submitted. The question, I think is very interesting. They say like, what should individual be concerned about in regard to their data privacy?
Whatever that you have mentioned earlier. So I think the good thing about this decree is they actually said what individuals have to do as well. So it's not just what businesses have to do. It actually imposes certain obligations and responsibilities on the individual to make sure they know that they should be protecting their data as well. So there is a bit of a balancing act there. And so for individuals, I'll say, just don't share your data instantaneously and impulsively. Think about why and whether you need to provide all that additional information. So this is very important. I'll just give you an example on how with social media, this is an old story, but most of you will probably know how employees used to post their activities. And there were stories about one employee who took sick leave, but then he was sitting at a beach and posting it on Facebook, and then he got the next call from his HR. So I'm just giving a general example, but similarly, the principle is the same. You want to share your data responsibly as well. You have a certain responsibility to protect your own data. And I believe How will say from in banking, you actually impose that obligation on your customers as well, that they need to safeguard their PIN, they need to safeguard their cards, etc.
Sure. Actually, for the question, like what topic the data subject or an individual can be aware of or taken into account, I totally agree with the analysis that's there. But from business side, I would like to highlight one thing, that in terms of cooperation or work with the business, because the privacy journey that is really complicated and really challenge for all including the data subject or organization. So for example, when you see any data leak or data privacy incident, so your corporation and support to business to handle the case, that's also the key thing, because we not only keep the organization compliant with the law, but also keep your data maybe safe and more safe. That is just one thing to say.
And Chi, do you want to add anything? Yeah.
So as we say, right, it's also a responsibility of the user to think about what data they share, right? So from the business perspective, we, at least from GeoComply, we make it very clear what we will be accessing if the user choose to activate our software. We say it upfront, and if they decline, then they can use the software. But if they accept to use the software, they will be fully aware of what we are accessing. So that's sort of fair way, two-way agreement, right? So.
Yeah, so it's a good way to using this kind of technology and the culture that can help customer also aware of their data, right? The question from Zoom is how to create data privacy culture if you work with remote teams. That's very popular these days.
It's really hard question for me at least. Yeah, but you know, we say about the culture, about awareness, that's not only the one-off exercise, but also the long-term exercise. So I believe that for not only the remotely team, but also the physical team, that's really challenge. But we can think about some simple action like I did before. Yeah. When we talk about the personal data and we check the privacy, so at least the employee have to aware of what is the personal data, what is the privacy principle to protect their personal data and customer information, for example. And we have some maybe activity to do so, like the newsletter monthly, quarterly, to raise the cultures and the awareness. But also we have a funny activity like the mini campaigns or even the quiz with the really exciting gift, for example. Yeah, that is the small thing, but I believe that makes the difference. And the other thing, your organization can think about the external view, the external presentation workshop to take the privacy topic seriously in your organization and can be contribute more in terms of professional advice or professional view of the privacy. And we can engage with the external to share or train your employee. That's also the good point to implement. And the last thing, we have to have the involvement and engagement from all level of the employee. So we have to have at least the procedure, the policy to say that that require the employee to join in terms of the data privacy journey. Yeah, I think that's it from me.
Thank you. Anybody? Yeah.
For me, amongst the other things, training, raising awareness amongst employees on the importance, because we do that as businesses in any event, educating our employees on how to protect confidential data, clients' data. So this is just by extension to personal data as well. So yes, constant reminders through newsletters, activities is also fantastic because it stays at the forefront of your mind that you need to be protecting any data that you collect, be it personal or business data.
Okay. We have 8 minutes, còn 8 phút nữa, cho nên mọi người nếu mà có câu hỏi nào thì hỏi nhanh giúp mình nha.
Hello, I have a question specific for fundraising for NPO or NGO, because we have a fund page and we post a lot of children's image on that for every status. So if another stakeholder use that images to raise fund or to do for their business or their activity, and we don't receive any notification or any announcement from them, so what risks could we face, and how we can deal with that? Like should we ask for the fundraising report? Should we ask for the do we have the right to ask for that? Because actually we cannot ask like we don't aware, should we have the right to ask for the action, to ask for the use of the funds after their event or something like that. And if they raise fund for our children, they will send the report. But if we raise fund for many partner or not our organization, so what is the risk and what should we do? Yeah, thank you.
So when you raise funds, are you saying that you would not have had prior conversations with these organizations? So in there, you probably have to add a personal data privacy element to your discussions and about how how they would use any of your material. And but lately I've noticed that a lot of people, although seem to post children, but they're not posting children. So that's also something to consider. So like children on the side, children the back of a child or something. So, I mean, these are just examples that I'm providing, but yes, this is a conversation you definitely have to have with all your partners, and also about how you're going to include this personal data protection element and privacy element into your discussions, and build in some protections and safeguards as well. And still be able to raise funds.
Raise one, yeah. That's a really tricky question. Yeah, okay. Great. Angie, do you want to add anything? Okay, so I think we have a few minutes left. If anybody have question, please submit that in your chat box or here. But the question I think very interesting to a lot of people here today is submitted by the audience. So what are immediate action companies should take to ensure compliance with Decree 13? Immediate action.
Okay, I will take that question from business side first. Yesterday, I have a chance to join the workshop hosted by Ministry of Public Security, and they present something in terms of Decree 13 implementation. And they expect to launch the portal to receive the data incident notification, and also the documentation in terms of privacy impact assessment. That is really strict timeline for organizations now under the Decree 13. You just have 72 hours to report on the data incident. You just have 60 days from the processing day to submit the privacy impact assessment documentation to MPS, and they launch the portal to do so. That maybe requirement will immediate effect to our procedure. So that also the thing we can consider to implement at this time. But again, when we set up the key prioritize or minimize scope to implement at this time, given the short time to implement, it really depends on your business side, your risk appetite, and also your awareness or a culture in terms of privacy. So that also the thing we can consider. Yeah.
I agree. It very likely than not. Now everyone is on high risk. And then, but the good thing is this risk would become lower and lower as you comply. So that's what you have to look at. And also, like our suggestion, that start making effort in mitigation, review, conduct a gap analysis, and then move forward. Like Ha has just shared the roadmap. So, and but yes, it's start. It's never too late.
Thank you. Ji, want to give some sort of advice or suggestion?
If I were a business in Vietnam, I'll consult them right away. I consult them right away.
So we have another one to get the budget for the technical side, right?
Yeah. Right. Now you're talking about budget. Anybody? One more question? Yeah.
Quick question: Do we have any organization in Vietnam provide advisories on gap analysis to prepare enterprise to access their own readiness?
There are plenty. KPMG, for one, provides a service. We provide an end-to-end service because I am from KPMG Law, the law firm, but I work closely with my colleagues from the risk consulting teams to put together a scope of work. And we are in discussion with multiple clients right now. I think I'm eating, sleeping Decree 13 right now. So because we want to help organizations, it's not because, this is a great opportunity, but it is something that we want to do as well. And it jives with our values. So yes, and there are law firms, there are other consulting firms, software companies who provide this. So there is plenty. I don't think there's a shortage.
So the answer is start now and asking people.
Yes, please consult.
Yeah.
Whoever you consult will be able to point you to someone who can help.
So thank you so much for all your insight, experience, and knowledge. And I believe it's going to be very helpful for a lot of people. But of course, because the time is limited, so if you have any question for the speaker, please submit it to us, hello@geocommunity.com, and then we can send it to the speaker and they can answer you more after that, right? And I'm not sure about the permission to use the slide, but I will ask the speaker if they allow, I will share the slide with you too after the event.